Good evening, everybody, and welcome to our talk on Stop and Search, as hosted by the Black Men in Law Network. This is one of our first events that we've run like this. We haven't done any really virtual talks, so we're really excited to bring this to you with sort of what's going on around within society right now, and has been a long-standing issue within society, particularly people within our own community. We felt like it was quite important that we actually put this on to ensure that people are well equipped with just what they can do in certain situations and what rights they actually have when confronted with certain situations that they might need to be able to kind of hold their own. And so, as I mentioned, this is hosted by the Black Men in Law Network. My name's Nwadikwa-Jonathan. I'm a future trainee at Gowling WLG. This isn't anything to do with my jurisdiction. I'm not within that field at all. And so I will soon be handing over to a few people who are experts on this. And so I just wanted to give you a little bit of an insight into who Black Men in Law are and why we exist and what we do. And essentially we are a community of, as the name says, Black men in law. We've been established since around 2018 now. And essentially we exist as a group to empower the Black men who currently exist within the legal industry. So whether that's needing advice, whether that's kind of needing somebody to speak to about something that's happened to at work, or whether that's just to kind of gain a bit more insight into certain areas of law and different areas of business. But we also work to support to increase diversity within the legal industry, specifically amongst Black men in law. And that's probably our main jurisdiction and what we we exist to do. We understand that there is a massive lack of Black men who currently work within the legal industry. And so we were established to almost action and ensure that we as a community, as a group together, can work to increase that number. And so, again, around the issue of stop and search and sort of why we're having this and stuff like that, you know, just to kind of reel off a few statistics that concerning particularly young Black men. So, you know, young Black men are stopped and searched 20,000 times, young Black men were stopped and searched 20,000 times during the lockdown period, which of course isn't a very long time. We knew it as a couple of months. However, only more than 80% of those searches resulted in no further action. So these Black men were stopped, they were searched, and there was nothing to be found, and they were allowed to carry on with their days. And, you know, 20,000 is such a large proportion, it's such a large number, and for 80% of that to come back with nothing, it kind of, you know, it can be said to be a worrying statistic. In the space of 1 month, more than 1 in 10 young Black men was stopped and searched. And again, they were found to be carrying nothing. Black people are 10 times more likely to be stopped and searched than their white counterparts. And so these sort of statistics, when we reel them off and we understand that, you know, this is a reality of some, and for some people, and most particularly people like us in our community, we understand that we have a duty, we have the knowledge to be able to equip them and essentially help them within those situations as to what they can actually do. And so essentially that's why we're having this talk today. And again, the purpose of this workshop it's not to challenge live searches, but essentially it's just so that people are better informed about what their rights are and what they can do in certain situations. And, you know, we're here to essentially support people through that. So again, that's enough about me and enough about what the Black Men in Law Network do. I'm going to go on to introduce our panelists who will be taking us through certain sections of stop and search and different elements and just what it contains. And they'll be able to explain further a lot better than I ever would have been able to. So just to briefly introduce our panelists, we have Nwadikwa-Jonathan from the CPS. We have Shina Animashaun, who's a barrister from Garden Court Chambers, and we have Etienne, who's a barrister at No 5 Chambers. So I'm going to hand over to Andre, who will be taking us off with our first topic. Thanks.
Well, first and foremost, thank you to the Black Men in Law Network for inviting me to speak, and of course to the attendees for the interest that's shown in the topic. This is really unprecedented in the work that we've done so far, and to have, I think it was in excess of 800 people apply in the end, this is really astounding, but it shows the importance of this topic at this particular point. As you've heard, my name is Nwadikwa-Jonathan. I am a barrister employed by the CPS to prosecute. So my practice predominantly consists of crime. I occasionally dabble in extradition and have a background in international law. But for the most part, you'll find me prosecuting adult and youth cases in the criminal courts. Now, as to the purpose of the talk today, I think in the first instance, it bears mentioning that it's disappointing that we're having to have this conversation in 2020. I didn't grow up in a particularly rough area or anything else like that. I grew up in a very sleepy southeastern suburb in southeast London, and I was stopped and searched more times than I would care to mention growing up. And this was many moons ago in 2004, 5, 6, and so on and so forth. And yet here we are, we're still having the same conversations and the same issues persist. But to be forewarned is to be forearmed. And we're having this discussion because we believe there's a real value in knowing your legal rights and the obligations that are owed to you by others. So for the most part, the aim of the discussion, well, the aim of my discussion, and of course that, if I may be so bold as to speak on behalf of my colleagues, the aim of the discussion that you hear today is to demystify stop and search. At the outset, I must, as a caveat, of course, I'm speaking in my private capacity and not on behalf of the Crown Prosecution Service, although my experience as a prosecutor will, of course, inform some of what I would like to discuss. So I'm going to demystify reasonable grounds for suspicion, which is the most commonly used basis for a stop and search. So first and foremost, what is it? Reasonable grounds for suspicion is the requirement that police officers must satisfy before they are lawfully able to stop and detain someone for a search under certain powers, which I'm going to elaborate upon in due course. And this is a mandatory requirement and it must be applied in each case. But what does it mean? The term reasonable grounds for suspicion isn't actually defined in law. It's not defined in any of the legislation. Where it is elaborated upon is the Police and Criminal Evidence Code of Practice A, which is the code of practice that regulates police stop and search and public encounters, specifically paragraph 2.2, which sets out what's called a two-part test, i.e. a requirement that has two parts. The first part is that the officer must genuinely suspect that they will find the item searched for. The second part is that it must be objectively reasonable for them to suspect this given the information available to them. So taking both of these in turn, step one, the officer must genuinely suspect that they will find the item searched for. What does this mean? Well, this is a subjective test, i.e. it relates to the mind of the officer who is conducting the search. But in short, it should relate to the officer's belief in the likelihood of the person that they're stopping being in possession of the prohibited item. And this must be grounded in a specific explanation. That's not this is not guidance, this is a requirement. It must be grounded in a specific explanation. The College of Policing, which is the regulatory body which is essentially responsible for training the police and setting these standards that they must adhere to, states that the officer must be able to give a specific explanation for suspecting the person of being in possession of the item based on specific information or intelligence or some particular behavior. What does that mean in short? It means that the suspicion must be a genuine one. They elaborate on this even further, and they say that notably, even for an experienced officer, this must never be based on a hunch. It can never be based on a gut feeling. It can never be based on a general suspicion about a person. Turning to the second step, it must be objectively reasonable for them to suspect this given the information available to them. As is clear, this is an objective test. i.e. this is one that a person with the same information that police officer had could come to that conclusion, and it must be reasonable for them to do so. And this really is why it's so important that officers give you a specific explanation when you're subject to a reasonable grounds for suspicion, stop and search. Because they have to provide this detailed reasons, because this is what shows that other people with the same information available to them would come to the same conclusion. And the emphasis here really is on these reasons being objective, i.e. not based on subjective personal feelings towards a person or indeed a group, which is quite important given the current context and the particular circumstances in which we're delivering these presentations. The College of Policing themselves state that these reasons cannot include physical appearance, they cannot include previous convictions in and of themselves without any additional context, they cannot include stereotypical images and generalized assumptions about persons belonging to a particular group. So, for example, they state that assumptions based on generalization or stereotypes would include, for example, and this is noteworthy, the notion that people belonging to a particular ethnic, social, or age group, or wearing a particular hairstyle or item of clothing are likely to be involved in offending or commit a particular type of offense. In short, wearing a hoodie does not make you a gang member, and that in itself is not a reasonable basis for a stop and search. And if the search is based on personal factors alone or is not objectively reasonable, it is not legally justified and may lead to an adverse claim. So turning next to the requirements of stop and search specific powers, and the two most notable examples are Section 1 of PACE and Section 23 of the MDA 1972. So PACE is the Police and Criminal Evidence Act 1984, and Section 23 of the Misuse of Drugs Act. So there are various procedural requirements that the officers must adhere to. I'm not going to go into too much detail about that at this stage, but essentially it's what's called go wisely, which is the ground for the search, the object for the search, whether there's a warrant, and so on and so forth. But to compare and contrast the two differences or the main similarities between Section 1 of PACE and Section 23 of the Misuse of Drugs Act, what's the similarities first and foremost? Both Section 1 and Section 23 require the reasonable grounds for suspicion test to be met, for one. Number two, both permit the officer to search your person and your vehicle if the power is being executed. But there are two major differences between Section 1 and Section 23 and their execution. Section 1 of PACE is generally used for stolen goods or for items used in connection with theft, fraud, or criminal damage, and on certain instances for weapons as well. Section 23 is specifically for controlled drugs. So that's the reasons of the search. The second is the permitted location of the search. Under Section 1 of PACE, you can be searched in a public place or a place where the public have access. The rationale underpinning this, for example, is that the possession of a knife in your home is not illegal, but the possession of a knife in a public place is. So for a Section 1 power, many of the things that they cover in your possession in the context of your own private home may not be a criminal offense. But for Section 23, which is for controlled drugs, that power can be exercised anywhere, the basis being that drugs are illegal in every place in this country. So the final point that I'd address you on is the lawfulness of the search and how this may or may not affect the decision to prosecute. So when the prosecution are making a decision to charge someone, they apply what's called the full code test, which comes from the Code for Crown Prosecutors. And this is a standard that both public and prosecutors must adhere to in order to make legally founded decisions, or legally accurate or legally correct decisions, as it were. This consists rather of two stages: the evidential stage, which is an analysis of the available evidence, looking at its reliability, its credibility, and importantly, its admissibility. And they use this test to determine whether or not there is a realistic prospect of conviction. The second stage that must be applied is the public interest stage, and that's applied if the evidential stage is met. As regards the lawfulness of a search and the evidential assessment, well, one of the only circumstances in reality in which the conduct of a stop and search will lead to a case being stopped on evidential grounds is where the evidence is excluded under what is known as Section 78 of PACE. This is a very high threshold, as Section 78 requires that the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. In other words, what they're saying is it has to have been so unfair, the manner in which this search was conducted, that the court conscionably should not even hear the evidence. As is clear, this is a very high threshold, and the Court of Appeal has repeatedly refused to accept the use of improperly obtained but reliable evidence has adversely affected the fairness of the trial. So in the circumstances, given this high bar and the consistent line of jurisprudence from the Courts of Appeal, it's unlikely that an improper search would affect the evidential assessment. The public interest assessment is a slightly different category. There are a number of factors which are considered, which include the culpability and the age and maturity of the defendant. So looking at culpability, for example, one can foresee a situation where an officer seeks to conduct a drug search, for example. The young person in question has been stopped and searched by the police on 7 occasions in 7 separate days in that week alone. He's very frustrated by the situation, starts shouting or making a scene or generally being disorderly. And whilst nothing may be obtained from the search, they might then find themselves being prosecuted for a public order offence. In the circumstances, there could be an argument that their culpability is somewhat reduced because of the content issues that they're having with the police, or there could be an argument that their age and maturity affected the way that they reacted in a situation, and so on and so forth. I mean, this is all hypothetical, but these are things to be considered. And I think this is really the biting point, as it were, when it comes to the lawfulness of a search and how that might potentially impact the decision to prosecute. But even then, absent other factors, it's really a coin toss as to whether or not that would ultimately affect that final decision. So to summarize, for reasonable grounds for suspicion, you need 2 key elements. The officer must genuinely suspect that they will find the item searched for. For one, it must be objectively reasonable for them to suspect this given the information available to them. For 2, the objective reasons can never be based on personal factors such as your physical appearance or stereotypical images and generalized assumptions about persons belonging to a particular group, such as ethnicity, social or age group, or your hairstyle or your clothing. As regards the most commonly used stop and search powers that have the reasonable grounds of suspicion requirement, you have Section 1 of the Police and Criminal Evidence Act, which enables police officers, or empowers them rather, to look for stolen goods, items used in connection with theft, fraud, or criminal damage, and certain types of weapons. And Section 23 of the Misuse of Drugs Act, which empowers them to look for controlled drugs. Both require the reasonable grounds for suspicion test to be met. Both permit the officers to search your person and your vehicle. One can be used absolutely anywhere, that's Section 23 when they're looking for drugs, and one can only be used in a public place or where the public have access. And just to whiz through the decision to prosecute, as regards the evidential assessment, it would really only impact the evidential assessment in circumstances where the impropriety of the search is as such that it leads to has such an adverse effect on the fairness of the proceedings that it ought to be excluded, which is a high threshold. And it may impact the public interest assessment insofar as it might impinge upon the culpability, rather, of the defendant, and it might, when viewed in tandem with their age and maturity, lead to successful representations being made.
Brilliant. Thank you so much for that, Andre. It was extremely informative, very informative for myself as well. Just to keep the ball rolling, I'm going to now pass over to Shina, who will take us through no suspicion searches. So, Shina, whenever you're ready.
Thank you. So I'm just going to share my screen, and hopefully you can see me. Danny, can you confirm if I can be seen? Can you see the screen?
I can see your screen, yeah. I can't see you.
Perfect. That's totally fine. So I'll start from here. Okay, I just wanted to take you through. Sorry, just gonna have to cut this because this is acting up. Okay. So I'm going to be taking you through what Section 60 of the Criminal Justice and Public Order Act 1994 means for you. Now, this specific section provides a power which is essentially the most far-reaching stop and search power the police have. It's a power given to the police which allows them to stop and search you without reasonably suspecting you of anything. So before I do that, I'm going to just briefly touch on who I am and what I do. So I grew up in East London, Hackney, Pembury Estate to be specific, and I grew up in a family with 4 siblings and my mum, and British born, but of rich Nigerian heritage. Now, like many people from my estate, I went to a state school. And whilst at that state school, I took the opportunity to explore different fields of work, whether that was in the arts, financial services, or law. And when I stumbled on law, I felt inspired by the work that I saw in terms of just being able to represent people and just be able to articulate themselves before the courts in ways that they wouldn't be able to do themselves without representation. So from there, I decided I wanted to go to university to study law. I went to Swansea University and I graduated with a first. That laid some foundation which enabled me to get a scholarship and go to law school. And when I got to law school, on finishing, I was called to the bar. And through that and having that background, it allowed me to push into areas that I was really interested from school days, which I haven't touched upon, which essentially justice in the form of what happens in our communities, but also on an international level. So then I decided and I applied to go work at United Nations. And in doing so, I worked in prosecuting war criminals and spies, and also assisting refugees who are being persecuted. And now what I do is practice as a barrister from Nwadikwa-Jonathan Chambers. And essentially, I'm a criminal barrister, but some of my work covers areas of civil liberties and human rights. And I think that's a good transition into talking about your rights, specifically your Section 60 and how it works then. So in terms of a context and a background, I'll tell you a little bit about when they can be put in place. Essentially, a senior police officer, and it's a mandatory requirement on that officer, has to believe one or of 3 factors apply to a specific area or road, and that's in order for them to put in a Section 60. In summary, what it is that they anticipate there'll be serious violence will take place in a particular area, or they have reasons to believe, good reasons that is, that a person is carrying dangerous weapons or instruments, specifically guns and knives, in a particular area, or an incident has happened. So maybe you've heard in your area that someone was shot or someone was stabbed, and the police believe that someone's walking around in that area with a weapon that was used in that crime, or more weapons in the area. So what they'll do, they'll put a Section 60 in place. And like you can see in this map, they'll cover a particular area. They'll line it out, and that's the area. So if someone enters that area, that's where they can carry Section 60 stop and search from, and it can last essentially, and it can be put in place for up to 24 hours when it's first put in place. But even that can be extended for a further 24 hours if it's been extended by a senior officer above the officer who put it in place in the first place. So normally a senior, an SI, a senior investigator or higher in terms of rank. So what I've put here is an example map, and that was from the protest for Black Lives Matter, where it was a day where there was the counter protest by, in the news as it was said, EDL and other similar groups of people who came out. And here you can see that it covers an area, Hyde Park, Parliament Square, other areas like that. So that's an example of one that was put in place. By another example, you may remember a few years ago when the rapper / singer Notes was at Notting Hill Carnival when he was stopped and searched, and people were wondering why was he stopped and searched in Notting Hill. Well, at that point, there was a Section 60 in place which allowed the police officers to go into the area and search anyone and everyone without having reasons for doing so, beyond the fact that they believe there's knives and weapons in the area. So that takes me on to your right specifically, what you should know about it. Well, I've already told you that a police officer can stop and search you if you're in a specific area. So if you enter that zone, like I've shown you on that map that's laid out, if you enter a zone that they've put Section 60 in, if you're a pedestrian, you're walking past, they can stop and search you. That also applies if you're driving through an area. They can require you to stop your car so that they can search you and your vehicle, again, for the purposes of searching for weapons, for the reasons I've already identified. The next is this. It allows a police officer to, like I said, stop and search you without having any reasons to suspect you of anything. So it's not like what Andre was just talking about moments ago, when in terms of drug searches or other searches like that, where there is a requirement. It's the obvious point that I've been saying, the underlying thing around this whole point of Section 60. So the next thing after that is also that a police officer must be wearing uniform to conduct a search under Section 60. In terms of what uniform is, basically they're anything but wearing civilian clothing. So if they're in a suit, if they're in a hoodie, they can't be lawfully using Section 60 powers. But that being said, that in terms of being on the street at that moment, being stopped by the officer, there's nothing on the street then and there for you to be able to challenge beyond you saying, well, you're not in uniform, I don't trust if you're a police officer, yada, yada, yada. The point is, it's a kind of issue that can be dealt with at a later stage in terms of what was the result of that whole search, because you could look at it and say, well, was that a lawful search because of little requirements like that? In terms of how they approach it, police guidance says that they should try and seek your cooperation. In fact, they must try and seek your cooperation in terms of the stop and search. They have an option of using force to conduct a search, but that's only if it's established that you're unwilling to allow or permit a search, that they have powers to use to conduct such a search. So really, it's only a method of last resort should they be using any force against you. And we've seen on social media circumstances where police officers haven't really been using it as a form of last resort. So again, it's the kind of things that are dealt with after the fact. So that takes me on to the next, written statement. So some of you may have heard of this before, and I've essentially laid it out on a slide. It's dealt with in one of two ways. If no arrest results from the stop and search, they must give you at the scene, there and there, a written statement that you were stopped and searched, and it will cover a number of factors. Now, they have to do that unless it's impractical to do so. Some kind of technical issue, they haven't got their notepad or anything like that. And if that happens, well, they're supposed to tell you that you can collect that information from a specific police station within this period. And they really have to do it within 12 months, really. If you're arrested for whatever reason, such as some circumstances, whether it's because, I don't know, like drugs are found, or they consider you're resisting arrest, or because of anything alike, the officers have a duty to record that in a custody record. But if you get to a station and still it doesn't result in any further action, then it results back to that point I've said, that's point A. They should give it to you then and there. Now, the next point is this. Well, what happened if you fail to stop? What happens if you decide to just ignore them because you say, well, you're not in uniform, or I definitely haven't got weapons. Like, why are you wasting my time? You're stereotyping me. You're racially profiling me. Well, the difficulty is that it is an offence for you to fail to stop. And it comes under section 60. And essentially, if you fail to stop when required to do so by an officer, you can be charged with this offence. And the sentence is for up to 1 month imprisonment and or a fine. There are various ways that this could be tackled in terms of approaches in court, but that goes beyond the ambit of what we're doing today, and hopefully it won't have to go that far. So last thing, in terms of section 60s, some of you may have heard about it but wondered, well, how am I supposed to know when I leave my house that section 60 is in place? Well, try and just have your wits about you. The police have even criticised themselves in terms of how well it's publicised. Here I've put an example of one that was publicised in Hackney. Here you have a verified Twitter page. You can find verified pages, whether on various forms of social media, Facebook, Instagram, and the police will essentially announce that there's a section 60 in place. They'll put up a map like I've already shown on the slides previous, saying this is the area. Often, sometimes they'll also say this is what's happened in the area, or we anticipate this is what's going to happen in the area, and that's why they've put it in place. So that's how you can kind of stay informed for yourself, for your brothers, your sisters, your children, your friends, and your family, and have your wits about you. So essentially, that is the end of my part, and I will be handing it to Mr. Etienne.
Thanks for that, Shina. Brilliant presentation, brilliant animations as well, which I'm sure will prove very, very helpful for people who are listening in. And so lastly, I'm going to hand over to Mike Etienne, who will be speaking on mandatory vehicle stops under section 163 of the Road Traffic Act.
Great, thanks so much, and thanks for inviting me to join the panel. I don't have a glitzy PowerPoint presentation to show you, but that's partly because my section of the talk is about, at least on paper, a much simpler police power to stop vehicles. But before I get to that, a little bit about myself. So I am a barrister practicing in public law and actions against the state, particularly actions against the police, currently at No5 Chambers. I have been qualified for just coming up to 2 years, but I've been working in law since around about 2013, 2014. I was one of the first in my family to go to university and to get my law degree. I was eventually called to the bar in 2012 and had quite a long and winding road before I eventually managed to find myself as a full-time practicing barrister in my own right. I've always had a kind of long interest in getting into the law, and I'm really keen to help offer advice and support to other people who are interested in getting into the law as well, and especially trying to make the law and the legal profession more, not just more diverse, but more inclusive. And so that's one of the reasons why it's great to be part of this network, because it allows us as Black men in law to kind of get together in spaces that are sometimes more comfortable than the ones that we find ourselves in when we're out in court or sometimes in chambers or in other places. So back to police powers. So Section 163 of the Road Traffic Act basically gives the police a power to stop or require to stop anyone who's driving a car, but also importantly, anyone who's on a propelled vehicle, which means that you are also required to stop if you're asked by a police officer if you're on your bike. Now, on paper, this is an incredibly broad power. The police don't have to have any explicit reason to stop you. They don't have to have reasonable grounds to suspect that you've done anything wrong or that there's anything wrong with your car. They can just require you when you're on a public road or in a public place on your bike to stop. So you might think, well, what safeguards, what protections do I have against the police misusing this power? We've seen really recently a number of controversial, potentially unlawful stops of people in their cars. We've seen the incident with Bianca Williams, for example, and it's really difficult because not only is the power very broadly written and doesn't require reasonable grounds of suspicion, but we don't collect the data about stops under 163 in the way that we do with stop and search. So although instinctively, anecdotally, in our communities, we know that it's a power that has effectively created the offence of driving while black, it can sometimes be much more difficult to show that in data. And we know at the moment there's this kind of focus on, well, is there data to back this up? Because apparently, life experience and evidence by experience is not enough. The reality is that when it happens to you, if you're driving your car and the police signal you to stop, then you're required to stop. And if you don't stop, it's an offence. There are limits on that power, but they're often limits that you can only check afterwards. So the police should only be stopping you under this power for a policing purpose. So because the typical example obviously is driving erratically or some potential damage to your car or something that falls within policing purposes, but obviously policing purposes are quite broad. Other protections are that all of the legal prohibitions on discrimination, all the things that make discrimination unlawful in law, also apply to the exercise of this power. And when they're exercising this power, the police have to make sure that they're not using it in a discriminatory way. So all the points that Andre was making earlier about not trying to base reasonable grounds on stereotypes about certain communities or certain people, or the way some people look, they would all apply equally to Section 136. So in other words, you can't stop a young black man because he's driving a nice car. That gets really tricky in practice, right? Because often we'll see the police will say, well, we have local intelligence about insert criminal activity in this area, fitting the general description of typically being young and black and driving a car. And so it can be very difficult to get behind that. And what I would say is that if you feel that you've been wrongly stopped in your car, then you should seek advice from a lawyer who can give you more kind of specific advice to your situation and give you advice about, for example, making a police complaint, or whether you might have a legal action that you could bring. What's important to know is that Section 163 is just a power to stop. It's not itself a power to search your car or to search you. In order to search your car or to search yourself, the police have to use their other search powers, which would typically involve having reasonable grounds to believe that they're going to find something that you shouldn't have in your car. And if they were to search your car without a lawful reason, then you could potentially have a civil claim that arises from that. But again, it would always depend on the circumstances. And in many cases, one of the difficulties that the cases can be low value, which can make it difficult to get coverage to bring these cases. And whether that's by insurance after the event or potentially eligibility for legal aid because of the way that the legal aid rules work. So it's a very, very broad power. It's very straightforward to use, and we know that it can be very difficult to place a check on it. But what I would say is don't despair. There are things that you can do, especially if you feel that you're encountering this a lot. So if you're being stopped often by the police, you should always ask for them to provide you with an explanation for why you've been stopped. Take the name and the details of the officers who have stopped you. Keep a note of when you've been stopped. And obviously, if you're also searched, search forms are really, really important evidence. You'll often find that police officers also are wearing body-worn cameras. You're entitled to access that footage because it's about you. And I'm going to come on to talk about some of the ways in which you can build evidence in just a second. One thing also to bear in mind is that you are entitled to film the police yourself. So lots of videos going around at the moment about different encounters with the police. So stops and searches, people stopped in their cars. There is no law against you recording police officers. What's really, really important though, is that if you're recording your interactions with the police, first of all, if you're doing it in your car, make sure that you're not using your phone whilst you're driving, because that is a criminal offence. And if you're doing it otherwise, make sure that you can't be properly accused of obstructing an officer. So in most cases, the recording is of stops and searches. So in those circumstances, for example, what you'd want to do is make sure that if it's you that's recording or if someone else is recording, that they're keeping a safe distance away from the officers so that the officers can't say that you're interfering in any way. You're likely to find that sometimes police officers will try to obstruct people from filming, ironically enough, but you are entitled to film as long as you do it in a way that doesn't obstruct a police officer. So those are all really important aspects of recording data and accumulating evidence, because one of the difficulties is where things happen often, unless you can find a paper trail, and we come back to this question about data again, it can be really difficult to either make a complaint or a complaint that really addresses all of your concerns. So record where you can, and also where you feel safe and comfortable to. Write things down yourself. Ask for the identifying information of police officers. You're entitled to at least be given police officers' lapel numbers or badge numbers, so that way you can start to build an evidence base. If you find that you can't record, for whatever reason, one thing that you might also think about doing is record a voice note when you can, as soon as you can after the event. And the closer to the event that you're recording information, the more reliable that information will be seen to be, particularly if you end up having to bring a case to court later, or you're trying to pursue a police complaint. So one other question that comes up often that people face is, well, where do I actually go for help? Obviously, we can't in this talk recommend that you go to certain places, but we can give you information about the organisations that exist to provide support to people who have been affected by the use of police powers. There are organisations like Stopwatch, who you might have seen. They've been running a crowdfund campaign to help support their activities during the course of lockdown, because obviously the demands on their services have been incredibly high. Also, another organisation, if you're going to protests, if you're involved in protesting anywhere, Black Protest Legal Support, the Monitoring Group. This is a community-based campaigning organisation rooted in communities, putting people in touch with lawyers, providing them with advocacy support and lots of other important initiatives. And there's also the Network for Police Monitoring, who do something similar. some really great work in providing information about what police powers are and how they can be lawfully used. And they're also running a project at the moment asking for people who were protesting during the height of the Black Lives Matter protests in the UK to provide them with evidence of their own experiences of encounters with the police. So if that applies to you, that's something that you might want to contribute to as well. And the last thing I'll mention, just for the purposes of this talk, is that there are some advice lines that are open, that offer legal advice to members of the public, and they include the Liberty Advice Line. And if you go, look up Liberty on the internet, go to their advice line, you can call that line to get some general advice about how better to deal with, or how best to deal with the particular difficulties that you're facing in your case. And I think I'll leave it there.
Thanks a lot, Mike. I think that was a brilliant way to end it. I think all of the topics that we've engaged with have been fantastic. But of course, we're going to have more questions from the people that are watching. And so I've just got a few quick questions to just pose out, and anybody who feels comfortable can answer. I won't pitch them to anybody in particular. But I'll just start off with one of the ones that we received, which quite a few wanted an answer to. And I know, Mike, you touched on audio and video recording whilst in your car, but almost what are your rights to record audio and video during a stop and search in general? So whether in a vehicle or outside a vehicle, what would their rights be around that?
So as I was saying, you're entitled to record the police. Do it in a way that you feel comfortable with. Sometimes people don't feel safe to record. Obviously, we have to be careful because of the way that police tend to react to us, that you avoid doing anything that looks like you're hiding something or making sudden movements or any of those other convenient descriptions that are sometimes applied to justify police action. But you are entitled to record. And of course, police officers are often recording you at the same time. So it's sometimes ironic when you see police officers objecting to being filmed when they're all now wearing body-worn cameras, but you are entitled to do it. The most important thing to do is make sure that you're not doing it in a way that can be described as obstructing an officer whilst they're trying to go about the course of their duties.
Brilliant. That's fantastic. I'll just pose another question. So when stopped, should a stop form always be issued, or are there circumstances in which stop forms don't have to be issued to the person that's been stopped, and that's to anybody?
Yeah, I think touching on what we discussed earlier. So in terms of the stop forms, by default, they should be issued then and there. There are circumstances which the guidance says that it may be difficult. It doesn't spell them out, but it essentially guides the police officers to say that if for any reason that it can't be provided, signposts to said person who stopped and searched how they can get that information at a later point. The only other circumstance is where they're arrested and that leads to them being charged and interviewed, and that information would be contained in a different place, not that form, but a custody record. And that is something that your solicitor, if you ever find yourself in that situation, can obtain to see that record, to see if there's anything concerning about it or helpful for you. So I don't know if I've covered all of that, but if anyone wants to jump on top of that, please feel free to.
I think the only thing I'd add is that if you, for some reason, aren't given your stop form, or you forget to ask for it, or for whatever reason, it's something you're able to go to your police station and ask them to provide you with. You're entitled to it. It's also worth bearing in mind as well that you can get other information that the police hold about you by making what's called a subject access request, sometimes called a data subject access request. And basically you just write to the police and say, can you provide me with copies of the information that you hold about me? And you could just leave it very general in that way. Or if you wanted information about something more specific, so, the police attended my house on a particular date, I want all of the information you hold about me in relation to that date. You can do that too. Sometimes there is an admin fee that applies, but it shouldn't be more than normally more than £10. And you can get more information about making subject access requests on the website for the Information Commissioner's Office, which is www.ico.org.
Brilliant. Thank you both for that. I think you covered that quite well. I'm just going to pose another question. What's the practical difference between the searches under section 1/23 and section 60? So, of course, we spoke about almost both on all of them. So what would be the distinct differences between them?
If I may fill this one, at least partially. Section 1 of PACE and Section 23 of the Misuse of Drugs Act require reasonable grounds for suspicion. So these are person and circumstance specific in that regard. Section 60, however, is region specific or area specific, and it doesn't require there to be reasonable grounds for suspicion. And in fact, it's one of the few such powers that is so broad. And this is the reason why in law it's supposed to be limited to a certain amount of time. It's not supposed to be an indefinite power which can be exercised by the police. Your Section 60 order would typically last for 24 hours unless extended, as Shina has very ably set out in his presentation. But the key defining features Section 60 is area specific, and Section 1/23 are person and circumstances specific. So that's the first. And the second is 1 requires reasonable grounds for suspicion, i.e. sections 1 and 23. The other does not. It doesn't require any legal basis whatsoever, bar the fact that a Section 60 order is in place.
Fantastic. I didn't know if anybody wanted to add to that, or is everybody okay with that? Brilliant. I'll just pose the final question, just being aware of time, and that would be, are the police allowed to put you in handcuffs even if you're not resisting during a search? So does it have to almost be reasonable grounds for them to handcuff you while searching, or is it completely down to their discretion?
Well, I think the starting point is that it's illegal for you to intentionally apply any kind of force on another person unless you have a legal justification for do so. It's an assault, plain and simple. You cannot unlawfully apply force on another person. So in those circumstances, for a police officer to apply handcuffs, they have to do so lawfully, and it'll only be a reasonable use of force, as police officers are entitled to do under various bits of legislation, PACE included. There's also a common law power in terms of their self-defense, which enables them to use handcuffs as well. But generally speaking, in order to use force, it has to be reasonable, it has to be necessary, and it has to be proportionate. And the decision to apply handcuffs has to be taken, again, based on objective factors in the particular circumstances of the particular case. Again, not based on personal factors, not based on stereotypes, not based on generalizations about particular groups, but based on the objective facts that are available to that officer. Now, sometimes these objective facts can be broad, and that can present difficulties at times, particularly if you're on the receiving end of the handcuffs. For example, it's not uncommon to see situations where a person is handcuffed because they are an unknown threat to the officer that's searching them, which essentially means that I don't know you, I don't know what you're on, I don't know what you've been on, I'm stopping you for this search and I'm worried for my safety, which it's questionable whether or not that should be a proper basis, but it is a basis that I've seen used in that regard. But the starting point is that any use of force has to be justified, and a police officer can only justify it if it's reasonable, if it's necessary, and if it's proportionate.
So just to build on to that, so what we see very often is police officers just reaching for their handcuffs straight away. It's almost like a default reaction is that handcuffs will be used. Now, strictly speaking, for all the reasons that Andre has alluded to, that's unlawful, right? They have to make an objective assessment that handcuffs are necessary, and essentially they should be doing that because they've got some reason to think that the person that they're about to approach, or whatever it is, might try to escape or might become violent or something like that, that there's some need to restrain them by using handcuffs. And if they don't make that assessment, or they don't make it properly, then that's technically an assault. The difficulty that you have with assault claims against the police, obviously, is that litigation is expensive and it's risky, and often the value of these claims can be quite low. So if you are in that situation, again, it's the best thing to do always is to seek legal advice, preferably from a solicitor who specialises in actions against the police, who can give you advice that best suits your circumstances.
Fantastic. And there was actually one more question that I did want to pose, and that would just be really quickly, is there an age requirement of stop and search? So is there an age minimum requirement before a person can be stopped and searched?
So no, there isn't. That might be surprising to some people. So you can't be held criminally responsible for any offence under the age of 10 in this country. But that doesn't apply to the power of stop and search. The limits on stop and search, normally it's section 1 of PACE, as Andre was discussing, is whether or not there are reasonable grounds to suspect that someone's carrying something they shouldn't, or potentially been involved in the commission of a crime. But there are also other general duties that apply to the police in terms of how they interact with young people, and that includes taking decisions that basically are in the best interests of children. And so sometimes what you can find is that those more general duties that often don't get talked about quite as much can influence whether or not it would be lawful to stop and search a 10-year-old. One of the difficulties in this area of law is because of concerns about county lines offending and the use of children as basically conduits for adults, things can get very, very difficult. But from my point of view, police officers should be very, very slow to be stopping and searching children. And the younger the child is, I think the stronger the arguments ought to be that stop and search is justified.
And of course, it's worth noting in the same breath as well that because there is no minimum age for somebody to be stopped and searched, there's no requirement in law that a person being stopped and searched requires the presence of their parental guardian or an appropriate adult or anything of that ilk. And I think that's something that's very important to bear in mind, as that is something which is commonly asked as well.
Fantastic. Thank you both for that answer. And I just want to round up by thanking you all for taking your time out this evening to be with us today. I found it extremely informative. There are a lot of sort of my rights around there that I wasn't fully informed about. And I'm sure that whoever this video reaches, the people that have been present, I'm sure it will be helpful for everybody. And, you know, us as Black Men in Law, we hope that we can do more talks like this on different issues that are affecting, you know, people within our community directly. And that's exactly why we exist here. And, you know, we're so thankful, and, you know, the fact that we have the privilege to have 3 barristers here on our panel to deliver this information. So thank you all very much for taking part tonight. Just a little note on our side, there are just a few things that I sort of want to run through that I want to mention about the network in particular, and some other networks that work quite closely with us. And so first of all, I just want to start off by reminding everyone about our socials. So our Instagram is BML Network, the same as our Twitter handle as well. It's BML Network, and our email address is bmlnetwork@outlook.com. At the moment, we're in a position where, you know, we're fortunate enough to have so many different lawyers within our group, and we're on hand to help, essentially. At the moment, we're keen to do more talks in schools. We've already started doing talks in schools around, you know, this sort of topic, around just career interests in law, how to get into law and stuff like that. And we're very keen to go into some of the most deprived areas to speak to students there as young as in year 10 and year 11, to just be able to give some information about how they might be able to navigate their way through their A-levels, their GCSEs and so on. And so if you do work with any schools, if you know anybody that works within a school that would like one of our lawyers come in and speak, we're more than happy for you to drop us a message on one of the socials that I've just mentioned. You know, we do local presentations and we also do future events as well. So our local presentations will be, we're more than happy again to go into communities where there might be community talks, different events around different issues, varying issues, and it might be worthwhile having somebody who has a knowledge of the law to be present at that time. And we also do future events. So one of our major things, and one of the things I'm most involved in, is working with some of our partner law firms who are partnering with us at the moment. And that's just basically around helping people who are seeking to apply, whether it's for a training contract, vacation schemes. We also have the bar side, so people that are applying to the bar or for pupilages. We're on hand to help, and that's why we're here, and we're really keen to push that and making sure that people are aware of our presence and aware that we exist to give back. We find ourselves in a privileged position, and for us, it's all about giving back to the community. We also run a mentoring program, so that's another branch of what we do, and essentially we're seeking to partner young people who have an interest in law and again want some more one-on-one time with somebody who is now within the legal industry and has a bit more knowledge, to just spend some time. It doesn't take up too much time, and of course with the current situation it would be virtual essentially, but we have so many people on hand that want to give back and help, and there'll be so many people that can benefit from such a mentoring program. So again, if you know anybody that's keen to find a mentor that's within the legal industry, please again just drop us an email, or you can message us on one of our social media handles. I just want to kind of speak about a particular fund that's going on at the moment that we're involved in. One of our committee members, Isaac Eloy, kind of leaning from our part, and we have other groups such as the Law Collective, Urban Lawyers from Tunde, and some other individuals, namely Mike as well, who are involved in an organisation called OCAT. So that's OCAAT. And in light of recent events, you know, we've kind of come together as a collective, and the purpose of this is to facilitate funding and legal representation for disenfranchised minorities with a specific focus on Black African individuals, including all Black people forming part of the African diaspora. And essentially what's been going on so far is we've launched a fundraiser in which we are attempting to create this fund to deal with matters specifically to what I've just referred to. And we hope that in this way we can increase representation for people that need representation. We can help people that are in situations that may be like these or other disputes where they need sort of that representation. So, you know, again, if you are somebody that's in need of something like that, we hope that once we get up and running, we can get that going. And, you know, again, if you're keen to help and you're keen to sponsor, that's OCAT, OCAAT. You can find them on Twitter or Instagram, and there's a GoFundMe at the moment for that fundraiser. And so, you know, again, if you're keen to support, we welcome all donations. And we just want to also recognise the Law Collective as a group, who have been another group of Black lawyers, which involves Black men and women in terms of supporting all of our events and supporting what we do. We also just want to mention Black Women in Law, who are quite a new group who have just started up, but again, very similar to what we're doing here at Black Men in Law, but for Black women specific issues. Again, you can simply find them on Twitter or Instagram by typing in Black Women in Law. And again, these two groups, they're two groups that are very, very keen to help, very, very keen for people to just to reach out to them really, and where they can find people to help, they will be giving back. And of course, there's Urban Lawyers as well, who's quite a long-standing organisation, quite reputable, and have done loads of things within the community. And so that's it from us this evening. Again, we hope that it's been very informative. We hope that you can share this video within your networks and to anybody that you feel will benefit from this. We hope to do more of these in future. So yeah, we hope you found it informative. We hope it's been worth your while. And we hope that we can do this again for you soon. Thank you very much.